We'll let everybody get, oh, you know what? We don't have, oh, there we go. I'm just going to give a minute for attendees to log on.
Do we get to see the attendees or not?
You should be able to if you look at participants. Okay, good afternoon, everybody. It is 12:03, and I see that we still have some people logging on. So we're just going to take another minute and give a few more people the opportunity to log on before we get started. Last I checked, we had about 16 people. So I'm expecting about 12 to 15 attendees besides the four of us. So, all right, well, I'm going to get started. All right, good afternoon again, everybody. For those of you who don't know me, my name's Bruce Matez. I am the coordinator of the Carl Cangelosi Webinar Series and the immediate past president of the NJAPM. Before we get to today's presentation, just a few quick announcements. If you have an idea for a webinar for next year, or you're interested in presenting a webinar next year, please send me an email. My email address is bmatez, M-A-T-E-Z, @wgpllp.com. I am trying to get the series scheduled for next year from September to June, hopefully before the summer if we can. So if you have any interest in presenting something or having a topic that you think might be of interest to everybody else, please send me an email. Next month on May 20th, Megan Bradley and I will be presenting a webinar on There's More to Family Law Than Divorce. We are going to spend about 10 minutes dealing with about 5 or 6 different areas of family law unrelated to divorce that people use mediation to help resolve those issues. There is one caveat. I was just summoned to jury duty on May 20th. So unless I can get out of jury duty on May 20th or postpone it or something else, we may have to adjust the date for next month's webinar. I will keep you posted. In June, Rick Steen is putting together a distinguished panel of civil mediators to present on the topic of building and sustaining your civil mediation practice. And I'll hope to have more information about that program, that webinar coming in the next few weeks. Again, that will be June 17th at noon. And today at about 12:30, I will announce the CLE code for today. I'll interrupt our distinguished panelists and give you that code. And if all you need to do then is send me an email with the code after the webinar today, and I will issue you the appropriate CLE credit if you signed up for CLE credits. And if you haven't signed up for the credits, you have to pay $25 for the credits. That's all my announcements. I am now going to turn it over to Margie and Glenn and Linda, and I'm going to put my microphone on mute and turn off my video, and I'll be back in about a half hour with the code. Oh, I'm sorry. One more thing. Forgot. Sorry. If you have questions, we'll take questions at the end. We'll leave about 10 minutes or so at the end. If you have a question, please put it in the Q&A. The chat is disabled for the webinar, but the Q&A is not. So put it in the Q&A, and I will present the questions to the panel at the end in the last 10 or 15 minutes or so. If you're unable to get one, you want to raise your question verbally. If you raise your virtual hand, I will call on you and give you permission to speak. Sounds a little military-ish, doesn't it? So when we get there. So Margie, Linda, Glenn, thank you for volunteering to do this today, and I'm turning it over to you.
Okay, good afternoon, everybody. Look forward to your questions at the end of our program. We are delivering a panel today called Civil Mediation, 5 questions, and we'll each take a lead on a question, but we'll all answer every, or try to address every question that we've organized for you today. But first, I want to start off with some introductions of our panelists. In addition to being moderator, I'm also a panelist today. So first, starting with me, I'm an independent arbitrator and mediator on a number of panels, including the AAA as a mediator and arbitrator, on the FINRA panel. I just joined She Resolves, a new organization focused on promoting women in ADR, as well as NAM, the National Arbitration and Mediation Panel. In addition to that, I'm on the federal and state courts panels in New York and New Jersey. My prior career was as in-house counsel or chief compliance officer, largely for insurance companies, financial services firms. So it makes sense that my concentration in my ADR practice is a commercial practice, focused on insurance matters, business matters, securities, and real estate. I'm a member of the Women in Dispute Resolution. I'm also a member of the Garibaldi Inn of Court, executive vice president of NJAPM, and a board member for NJAPM. With that, I will move on to Glenn Milgraum, who is a trial attorney with over 35 years of litigation experience. His litigation experience arises primarily from handling matrimonial and commercial matters, real estate, property disputes, collection, commission, and non-compete disputes, dissolution of corporations and partnerships, co-op and condo disputes. You get it. Commercial, real estate, matrimonial. Glenn has also been awarded the designation of APM by the New Jersey Association of Professional Mediators. He focuses his practice in New York and New Jersey, and more recently has become a member or a roster member in Florida. So he will be practicing his ADR in Florida as well. He's admitted to New York and New Jersey, as well as all the local, state, and federal courts, and is a member of the board of NJAPM. Linda Spiegel is also a member of the board of NJAPM, so you have 3 board members here. She's a member of the New Jersey Bar for 45 years, I don't say more than 45 years, 45 years, with a concentration in litigation and 34 years in an ADR practice. She has mediated and arbitrated over 1,000 cases in many areas of the law, including contracts, construction, consumer law, divorce, elder care, health and hospital law, insurance coverage, and family law. She's also a mediator and arbitrator for the AAA, for FINRA, and the New Jersey Rule 140 program. She is a founder of the Gene Robertson Women Lawyers Scholarship Foundation and SWAG, Seasoned Women's Attorney Group. Isn't that a really, interesting name there, of WLIB. She's a past president of Women Lawyers in Bergen County, a past trustee of the Bergen County Bar Association, and she's editor-in-chief of the WLIB newsletter, as well as of our own newsletter, NJAPM's newsletter. She's an executive member of the Garibaldi Inn of Court as well. So the 3 of us cross paths on many, many organizations and in our practice as well. That's our panel for today. And so let's start with the first question. And I'll be the lead in on this one, and it's whether mediation preparation is important. Without question, mediation preparation is important. You can't expect a good result without preparation. You need diligent and thorough preparation to ensure a good result. So I'm going to limit my comments to court-appointed cases. So what do I do in preparation for court-appointed cases? The first thing, unless you're in Middlesex County where Mark Pellicane sends you everything in an email, the complaint, the answer, and the background of the case, is that upon receiving an appointment from any other court, I go straight to the website and I get all of the documents. I get the complaint, I get the answer, I review what has transpired in that case as part of my preparation. And it leads you to this first question that you must ask yourself. As a mediator, the code of conduct requires you to be impartial, with no question. But it also requires you to be competent. So the first thing you obviously should do is to determine whether you're competent to take on that case. Assuming you are, and I haven't, received one yet that I didn't feel I was competent to handle, I email the attorneys and acknowledge that I've been assigned as a mediator in that particular case, and I send off my mediation agreement and mediation guide. Let me go straight to the mediation guide as why I send them this document, because in it, there's 5 paragraphs. It's not an intensive document, but let me read the second paragraph, which covers the role of counsel. And this is something that I start off from the very beginning in the email, sending them, and then I reiterate in every opportunity that I have to interface with counsel in the organizational meeting and beyond, right? And this paragraph says, as counsel, your responsibility is to draft an effective mediation statement. Explain the process and potential outcomes to your client. Advise your client of the strengths and weaknesses of his or her case. Focus on their needs versus wants. You should develop a plan for the proposals during the mediation. In other words, have proposals and counter proposals, think in advance, and let me know, lastly, if there's any insurance coverage involved. And the reason I send this mediation guide is I want to establish first in the minds of the counsel that I will be dealing with that I'm not a magician. It's a collaborative process. That's how I approach mediation. I approach it as a collaborative process where I say we have a problem here and we're all on the same team trying to resolve this problem. And so they have a responsibility, as well as I, to make this work, to make this process work on behalf of their clients. So going back to the website and my downloading of the complaints and the answer, I identify the legal issues that are going to be dealt with. I identify whether there are areas of dispute that there's agreement on already, upon which they disagree. If there's a counterclaim, it's going to be a little bit more complex than if you get a general denial, for example. And I begin to write down these notes, claimant's side, respondent's side, and start to track what I'm going to be thinking about in terms of a negotiation strategy going forward. And as I said, I use every opportunity thereafter, setting the table of this is your responsibility as well as mine, of repeating these messages to counsel in the organizational meeting and in ex-parte communications that I have with them down the road. From here, I'll move on to Linda, I believe, is the next person that's going to address how she prepares for mediation, and then we'll hear from Glenn.
Okay. So in terms of the preparation, I do it a little bit differently. And I let the 14 days pass because they can always, we're talking about court assigned mediations. I wait to 18 days and then I send out a letter. And that letter tells them that I've been appointed. I have scheduled a conference call. I go over confidentiality. And I ask counsel to sign the last page of the letter and send it back to me. I also ask them to forward me all their pleadings. When I get the pleadings, I review them and, see if there's law that I need to brush up on, or if I'm just going to wait until the organizational meeting. And I will be discussing the organizational meeting in the next question, so I will pass it off to Glenn now.
Okay, I tend to do it a little differently. I'm a lot more practical than most people. I realize that when it's a court-assigned case, we're not getting paid for the prep time. And because of that, I tend to limit what I do. The first thing I do when I get the letter from the court, because it's usually in the mail, I haven't gotten any emailed ones yet, is I check to see if I've had business with the attorneys before and I have their email address. If I don't have their email address, then I have to go to the court website, look at the jacket, and I take a glimpse at the caption just to get the email addresses of the participants. If I have to, I make a phone call and call them. But the first thing I do is I send out a letter that says, I've been appointed by the court. They have until such and such date as in the order to select a private mediator. If not, I am the assigned mediator. And in that letter, I include a Zoom invitation as to when I'm holding my organizational meeting. I set the meeting usually for 3 or 4 in the afternoon. I let them know it's going to be about 45 minutes or so, and that their clients are invited if they so choose to attend. And then at the organizational meeting, I take it from there, and I believe that's part of the next question. So that's what I usually do up front, at minimal amount of work until I actually have the organizational meeting and get involved as to what's going on in the matter.
Okay, so I'm going to take you to what the process is up to receipt of the mediation statements. So we talked about the organizational meeting. If there are only 2 parties involved, I usually do it via conference call. If we have more than 2 parties, then I'll do a Zoom meeting because it's too hard to follow who's speaking at each one. On the conference call, I ask each representative to explain their case, and if there's anything they need before they're ready for mediation. And I think that's really important because even though mediation is supposed to cut down on the amount of prep time that they have to save them money, if they're not ready for mediation, if there's something else that they need, what's the point? It's not going to go anywhere. And what I end up doing, and I've never had a case that said, yes, we're ready to go. Okay. So I set up a scheduling agreement and we discuss what's needed. If they're telling me they need interrogatories, I'm going to say, well, are 5 interrogatories enough? I don't start with is 20 enough or 25 or whatever. Do you need interrogatories? Maybe just a notice to produce. What are you looking for? And sometimes we'll actually put in exactly what the documents are that they need, to be able to go forward. But I think that's really important is you give them what they need so that they are ready for mediation. And then I set up what I could call a status conference where it takes place after they should have exchanged whatever document exchange or interrogatories they were going to do. And we go over everything, make sure that they have everything they need at that point. And then we actually schedule the in-person mediation session. Right now, I do them all via Zoom. If they're pre-COVID, I did it in person. I haven't had anybody object to doing it via Zoom. And this is when I set up also when the mediation statements are due. And just like Margie said, I tell them in their mediation statements, I'm looking for their wants and needs, okay? And then I do something else which they find very difficult to do. And I tell each representative that they have to include 2 scenarios for settlement that will satisfy the client. Because everybody knows what they want, they put it in their complaint, okay? But they haven't thought beyond that. And I literally tell them, I said, put yourselves in the other side's shoe, what they can come up with that you would agree with, and give it to me. Put it in the mediation statement. And then we have the discussion of whether or not the mediation statements are going to be confidential or not. And, you know, sometimes it's really a good idea to have them not confidential. And what they can do is separate out the non-confidential part from the settlement part. So the settlement scenarios are confidential, but the rest of the mediation statement isn't. And that gives all sides the ability to see where everybody else is coming from. And that can help things also. I will pass it off to Glenn.
Okay, I find the organizational meeting is extremely important. I get to speak to the attorneys one-on-one. I get to see whether or not they interact well with the other party. I always do it via Zoom, so I get more of a visual as opposed to a conference call. I don't like these attorneys that call and say, I'm in a rush, I got to get it done. I'm walking out the door, whatever it might be, let's get this over with, which some attorneys try to do. So I usually ask them at that point, what is the case about? So they could give me a brief understanding of what the complaint is about. I ask them whether there's any counterclaims, third-party claims. But the most important question I ask them is, where are they in the litigation process? Some courts send out the court order for mediation upon receipt of the first answer or response. And other courts, it's delayed because they wait till the parties request that it goes to mediation. And so I want to know what stage of the process it is at and whether I could help them continue. The next question I ask them, which is extremely important, is when is the discovery end date? I remind them that my mandate is that mediation be completed by the discovery end date, not after the discovery end date. I always let them know I'm available afterwards if they need me, but my mandate is to get it done prior to the discovery end date. I then help them set up some sort of calendar if they need assistance with it as to when certain discoveries are going to take place. Once we have that organized, I explain to them the need for a mediation statement or the non-need for a mediation statement. Depends on how complex the case is. I go one step further. I tell them, please limit your mediation statement to 5 pages, not counting the exhibits. Sometimes I wind up with hundreds of exhibits, and I think that is excessive for the mediation statement. In some cases, I go as far as to say, you know what? Don't even bother sending me case law. I'm not the judge. I'm not making a decision as case law. You're not going to convince me one way or the other with the case law you're providing. We're here to settle the case and to work out a settlement. And I want to know where the differences are with regards to the statement of facts. What's going on? What is the party's outlook? So there are many different approaches to the pre-mediation conference. And that's where I tend to focus. I'm sure I left out a lot. So at this point, I'll pass it on to Margie.
Well, hopefully they'll come up in questions from the audience. So this question that we're dealing with right now is, how do we conduct the mediation process, right? So I as well have a organizational meeting. As I indicated before, I want to have as many touch points with these attorneys as I can. So my organizational meeting is typically via Zoom so that we can eyeball each other and begin to build trust and rapport. reiterate what let me reiterate what I said before. I tell them and that this is a problem. We're all on the same team type of mindset, not litigation, which is win or lose, but rather we're trying to win for both sides. So we are addressing this in a collaborative way. I asked for, we set a mediation date. And then we go to the mediation statement due date, which, will, I will want at least 10 to 15 days before the mediation date. I don't put any page restrictions on it, but these attorneys, for the most part, don't provide you with 10-page mediation statements. That, at least that's been my experience. But if they throw in a case or two, hopefully, I remember during the organizational meeting to tell them to, if they cite any cases, to put in critical cases that they feel are helpful to their side. And I will read them, despite the fact that these are court-assigned cases and we don't get paid a lot for prep. But that's already in my mediation agreement as well. I tell them, if I have a New York mediation agreement and a New Jersey mediation agreement, and in New Jersey we have 1 free hour, for prep, and then we can charge for prep. So it's in my mediation agreement. They're aware of that, and then the 1 free hour for the mediation situation as well. But back to the organizational meeting, that's my second opportunity to stress the point with them that they have to come up with a negotiation strategy, that it's no fun to be involved in mediation where they're just bantering numbers back and forth, playing tennis, so to speak, with numbers without any thought in advance of whether they've calculated the reason for their numbers, what's behind their numbers, whether they have some information, for example, that they feel is so strong in their client's case that they're taking a strong stance with regard to their numbers. Those are the kinds of things that you want to ferret out in an organizational meeting. And when you receive the mediation statement, which I encourage them to exchange, because after all, it's going to come out during the negotiation process. If there's something in terms of their bottom line that they want to keep confidential, then they could separate that into an email to me or a separate document if they want to. And that's sort of like the same thing as I believe Linda indicated, to separate the confidential bottom line position. But generally, I want them to share their mediation statements so they can see in advance the stances that each of them are taking and how that is going to play out in the mediation itself, and also how that should influence their negotiation strategy. I share protocols, and I reiterate those protocols in writing before the mediation, protocols such as, stressing the 3 C's, as I call them, cost, confidentiality, and conflicts. So I let them know if there's any conflicts that I may have. I had a case with an insurance carrier where I am a subscriber to that insurance. I let both parties know that I was a subscriber to this insurance. It didn't stop them from wanting to use me in that mediation, but you use that opportunity to disclose any conflicts or any perceived conflicts that might arise. I talk about the cost, the free hour, the free mediation hour, the free preparation hour, so that they are also prepping their clients that this is not a free exercise on the part of mediators, that we're in business just as they are. And confidentiality, stress the confidentiality, that throughout the process, anything they say to me will be retained as confidential unless they give me the authority to do so. And that goes on during the mediation itself as well. where I will, before I move from one breakout room to the next, I will ask them, you know, and repeat, we discussed X, Y, Z, and can I share X, Y, Z, and get that authority before I go back to the other side of the room. And the other part that I do in these organizational meetings is try to set an agenda, because I have read the pleadings and I know what they're fighting about, and you know, want to establish that mindset as well. That mindset is going to be established again and again during the ex parte calls I'll make after I receive the mediation statement, because invariably there are questions I will ask or you know, nudges I want to make to them about their mediation statements. So you know, we will address that as well. And at the mediation itself, for all the parties, I will set an agenda, because I also think that it organizes their minds about what we're going to do that day, and to the extent that we tick off one and then go to 2 to 3, it helps them feel confident that we're making progress, that we are working on getting this problem resolved, all of us. Let me think. I don't allow opening statements. They invariably just heighten the emotion if there is any, so don't allow that. And explain to them that while they're in their respective breakout rooms, that's the opportunity that they have to do bio breaks, take calls, and take a snack or whatever. And that sometimes I will spend more time than the other side because of, you know, movement that has to be made, or just, you know, extensive discussion about an issue that has to be made in order for us to move forward. So that all the time you're setting expectations, you're setting an agenda, and you're maintaining a mindset of collaboration so that you get to a resolution. And that's my process in terms of conducting a mediation. I think the next question Glenn will lead us on, and it's, how do you set up the mediation room and what are you thinking about?
Okay, the rules and procedures that we just talked about are all important, and I'm sure that Linda and myself and Margie left out a lot that should be included in that. But now I want to talk about being a little more practical, especially for those of you who want to set up in-person mediations. And when we talk about in-person mediations, we have to really break it down to the basics. The first thing we would generally talk about is the shape and the size of the table that you're using for the mediation. Let's assume everybody has tables that are appropriate in size, but the shape is important. Not all of us have a triangle-shaped table, which would be ideal for most mediations, considering there's usually two parties plus us as the mediator, and you don't want to give any imbalance. Most of us have to deal with either round tables, square tables, rectangular tables, and sometimes you might be in a room where you could set up as many tables as you want to accommodate everybody. So let's look at the benefits of the different types of tables. A round table, again, gives a equal feel to everybody. However, when you have a round table, you have 3 parties. 2 of the parties are going to be sitting next to each other. Is that a good thing? Is that a dangerous thing? Depending on what you're doing. Matrimonial is a little more volatile than most civil cases. If there are attorneys involved, the question then is, where do the parties sit? Do the parties sit next to you as the mediator and have their attorney on the opposite side where the attorneys are sitting next to each other? What is the configuration, and should you as the mediator decide that for the parties? Sometimes it's better off to just be the last one to sit down and let everybody choose their own chairs. If you have a rectangular table, the issue then comes, do you sit at the head of the table with both parties on the opposite side? Do you sit at the shorter end of the table and making that the head of the table with one party on each side. You have to decide what you're most comfortable with. But when we talk about setting up the table itself, it's not just the tables. It's the things on the table, it's the things around the table, and where the table's situated. So we could take a look at what type of chairs do you have. Everybody should have the same make and model chair. They should all be the same height when they enter into the room, not having some lower and some higher, some on wheels and some with arms and some without arms. Of course, we're not all in control, but be aware that each type of chair is going to affect how people react in the mediation. If they have a chair with wheels, they may be wheeling themselves back and forth or rocking themselves. Those people who have chairs that don't move, it's stuck in the carpet, that may be very confining to them or a feeling of confinement. In addition to that, we have to look at the light source in the room. Is somebody sitting with the windows behind them where the window casts them in a silhouette? And if they're in a silhouette, can we see their facial expressions? That's always important to be aware of. Sometimes you might have windows behind people, but it's nighttime. And in that case, it may act like a mirror and be reflective. And the person looking into the window or the mirror may feel very uncomfortable. We always have to look at the doorway. Where is the doorway and how do people perceive it? Is that the escape route where the mediator should be the closest to the door? And so that should something volatile happen in the room, they can run out. That's usually the way it's set up in a courthouse so that the court officer could come running in. Or do you sit as far away from the door as possible and let people who feel like they need an escape route sit closest to the door? You'll find that people who are part of, let's say, a police department or fire department, or even somebody who has a criminal mind, they want to sit as far away from the door as possible so they can see if somebody's bursting into the room. So you got to look at the different people's comfort level with regards to that. But most importantly, we have to look at everything else in the room. Is it clean? Is it neat? Is it uncluttered? And what's going on with all those files that are in the room? Are they secured or unsecured? If you as a mediator are going to go do shuttle diplomacy between one room and another, and you have files that are open to people who want to snoop, you got a problem with confidentiality and people are not going to be comfortable with that. So make sure your files in the room are secured, put away. Yeah, sometimes you want to look busy, so you may leave the file cabinet on your laterals open so they can see you have many files to try to give them a comfort level. It's kind of the same feeling that people get when they see a glory wall. What do I mean by a glory wall? That which is, let's say, behind me, which has your diplomas and your photographs and organizations you belong to and stuff like that. Some people find that to be very intimidating. Other people find it to be, give them a feeling of security that the person who's sitting in front of it knows what they're talking about. So you got to kind of balance what's going in there, but let me break that down even further. What about some of your decorative items in the room? Or what you may not even consider a decorative item. Let's look at the wall clock. Is that a good thing or a bad thing? Some people may look at it as just decorations. Others might say, well, I'm watching my money disappear as we sit here and talk about the weather. And therefore, it's not a good thing to have in the room. So little things like that affect people. Look at the wall calendar you might have. If you have a calendar on the wall in the room and you have big X's and it shows all the days that have passed, people sometimes get on edge by that because it shows the passage of time. But a calendar could be very useful when planning ahead for scheduling meetings or visitation if it's a matrimonial action or the like. And
Glenn,
watch
you
out
really put a
for,
lot of thought into this.
oh yes, and watch out for all the little things that you do. You might have tissues on your desk for the client if they so need it. But in matrimonials, you find that sometimes used as a prop where they get to reach for
Can
the
be helpful when somebody's
tissue.
crying because of they're getting divorced.
Exactly. So
So
you
let's
got
hear
to
what
know.
Linda has to say about how she organizes her room.
Okay.
All right, so first of all, as I said, pre-pandemic, I would do it in person, but pandemic and going forward, I do it on Zoom. And my conference room at my office is a big standard rectangular table. And in civil mediations, I sit at the head of the table, which is also closest to the door. And I instruct everybody where to sit depending on how many people it is. We don't need any disagreements, from the beginning. And then they're not in there very long because I don't usually have a joint session for a long time. So then I separate them out. And that room is just a library. There are no files in there. There's nothing but books, okay? There are no windows, all right? And when I separate people out, the rooms they go into aren't rooms with files or anything that they can get into. But Glenn did a wonderful job of telling you the in-person. For Zoom, I may have, and I usually do after speaking with the representatives of the parties, I always ask them whether I do it in the organizational meeting or a status conference afterwards, or after I get their mediation statements and I get a clue that something may be going on, whether or not they feel a joint session is wise. Most of the time, they say no, they don't want a joint session. So when I bring people in from the waiting room, they come into what you're seeing right now on the screen. And there's really, it's not blurred, but there's not really anything that they can focus on, okay? And that's done on purpose. And that's because Carl taught us that way back when we were learning how to do things on Zoom. You don't want them to get distracted by anything that's in your office. So I bring them in, I go over the rules, I talk about the breakout sessions, I talk about confidentiality, and then I move them into breakout rooms. And the breakout rooms, again, you're just seeing the screens. You don't have to worry about files. You don't have to worry about tissues. If I had mediation sessions that started in the afternoon, I would put out chocolate and water on the table, a little extra energy, if people wanted. But on Zoom, that's up to them, whatever they want to do with it. So it's really different. And Margie, I'll let you take over.
Okay. I haven't put as much thought into this, I guess, as you or Glenn, because most of my mediations have been via Zoom. So as you could see today, I have a blurred background because I'm in my office at home and I have a lot of bookcases, a sofa, whatever, and art on the wall. And I remember during one mediation, one of the participants started commenting on my art on the wall. And so I said, nope, going forward, this will be blurred because I want everyone's attention to be focused on the individual, back and forth, eyeball to eyeball. We're here, we have a job to do, and let's stay focused on that job, not my art or whatever else is in my office. I don't have any particular rules when I'm doing Zoom, except that I do prefer and I do encourage the attorneys to have their clients in their office next to them. For the reason, I'm sure that we've all had this experience, that when the client is separated from the attorney at their home, for example, you might have a greater incidence of disruptions in terms of family and other people walking through, or dogs barking, etc. So when they're in an office, they're more focused on the problem at hand, and they're with their attorney, who presumably has stronger Wi-Fi and Zoom connections as well. So you cut down on technical issues, which is what we want, which is the environment we want to have. When I do mediation outside of my home office, I'm in a corporate setting or I'm in a law office. Invariably, the attorneys establish a room for each side of the dispute, and also I ask for a room for myself. Just like I do when I set up a mediation, I set up a conference room for myself so that I can go there and take breaks, so to speak, and review what's transpired so far, so that I know what the next thing is to do. So I have a room, a separate room in the corporate offices or in the law offices, and not only for me, for taking a break and resetting my mind on what's going on in the mediation, but also I invite the attorneys into that corporate separate room, or lawyers firm separate office that they provide to me, so that we can confer if we're stuck on something, or something has come up that we didn't anticipate and we should discuss. So that's all I do in terms of worrying about the environment. That piece about getting stuck is a good segue to our next question, which is about why do mediations end in impasse and what can you do to fix it? Remember—
Margie, why don't we let Bruce give his code at this time?
Oh, sure.
I was going to try not to interrupt, but also it's close to 10 of, so I just wanted to give you that heads up. But the code for today, everybody, is the !5, F-I-V-E, !5, F-I-V-E.
Thank you, Bruce. Okay, so I started to talk about our next question. Well, why do mediations end in impasse, and what can you do to fix it? Remember, this is a self-determination process. You as a mediator have to disabuse yourself that you have control over the parties, any kind of complete control over the parties. They have control, and they have control over the resolution. And sometimes they have unrealistic goals as to what can be achieved. And that might lead to impasse. Secondly, you might have attorneys that are, despite all the opportunities that you have brought to their attention, their need to strategize their negotiation, and they need to prepare their clients, et cetera, they don't. Even with regard to mediation statements, they just might give you some reworked memo that they've already submitted to the court for something else. And they don't give you the kind of mediation statement you really need. And all these factors can lead to impasse. Also, impasse can arise because the person in the room needs to consult with somebody else that's not in the room, some family member, some other individual that's influential, and you have no control over that. But what can you do? What can you try to do? You can try and reframe the issue as to where you're stuck. One of the things that let me think, that I did recently in a mediation was it involved an oral agreement of a loan of over $1 million for a hotel. And obviously the pandemic, well, not obviously, the pandemic disrupted the payment process. And so now the plaintiff wanted security. He had in his mediation statement at least 5 types of security that he wanted. So that was a big impasse point. So I reframed the matter and tried to get them to think about how they might prioritize these security requirements that they wanted. from most important to least important, so that we can whittle down those security requirements because they were causing impasse. So reframing the issue might be helpful. Brackets, having the parties give you ranges that they commit to, and then choosing between the brackets that they've given you, one bracket that encompasses both of their low and highs, the lowest low and the highest high, as the bracket within which you will continue negotiations with them. Another method or tool that we have as mediators to break impasses is the mediator's proposal. I rarely have used that. I feel like I'm putting my thumb on a scale, so to speak, but there are ways to do that softly, and that has occurred. Parties in a bank case that I had reached impasse, and we called it a day. We closed out that session. My follow-up with them was to say, hey, you did a lot of good work today. Think about how I can continue to help you. And so, you don't leave with, this is the end for all time. You don't need to continue discussing this matter. And within a week, after they had an opportunity to decompress, and I think in that particular case, it was an executive that was in the office with the one side of the bank that, the lawyer was trying to impress or something. But at any rate, within a week, that same person came back to me and I rethought this, and I think that we have time or space to move. And so I contacted the other side. Yes, there's space to move for us. And so we set up a bracket close to where they ended up the last time, and that did the trick in getting both sides to reconsider their positions and reach resolution.
Margie, because we're running out of time, I'm just going to simply say, when it comes to impasse, that creativity goes a long way. And if the meeting does end in impasse, it's not necessarily your fault as the mediator. If you see any movement or even discussion as to movement to a settlement, you're doing your job and you should feel comfortable with that.
I agree. And Linda?
Yeah, and I'll just chime in. Sometimes it's not an impasse that you can do anything about, such as if you're working with a governmental body, because they don't have the authority to enter into the settlement. They have to go back to their boards or their town or whatever. So that's something that you want to continue to follow up on, which was our next issue about whether you follow up after mediation. So it really depends on how you're finishing and who your parties are. So, think about that. I have a mediation right now that I got multiple condominium boards on one side. Okay, so they have one rep at the mediation, but then that one rep has to go back to all the boards, and all the boards have to agree because they're all plaintiffs. So that's, another way of doing things and how you keep that going.
That's right. Let me chime in on that last question that we have also, because I see that we have 5 minutes left, which has to do with how we follow up after mediations. I notify them in the email that a report will need to be filed with the court as to how we ended up. But I advise them as well that I won't be filing it for a period of time to allow, and also, again, thank them if we have reached impasse, that they've done a great job in getting to where they've gotten, and they should consider continuing to talk amongst themselves, and hopefully, maybe that'll encourage them to talk with me involved, but nevertheless, an encouraging email and a report to be filed at a later date. If they have reached a resolution, sometimes you have to follow up because one party is lagging in getting the agreement to the other side. So you stay involved, because remember, you're developing a business contact here who might come back to you another mediation someday. So the way that you continue to treat them in a positive way is an excellent thing. And unfortunately, sometimes you have to follow up with them because they haven't paid your bill. So that's another reason to continue to follow up with the parties that you've worked for. Glenn, do you want to say anything about follow-ups?
I think follow-ups should be limited to just making sure things are moving in the direction it's supposed to be with regards to the reports, as you mentioned. I try not to follow up with my mediation participants other than possibly to say, hope everybody was happy. Please make sure you make your payment on time. And if you want to give me a testimonial from my website, I'm willing to accept it. Other than that, I don't believe as mediators we should be following up because that may be misinterpreted as favoring one side over the other.
Okay, we appear to have one question.
Actually, there's two questions. I actually deleted one. The first question was, are you comfortable sharing with others your mediation guide?
Yeah.
Okay. So if anybody wants, you can feel free to contact Margie and she'll be happy to share it with you. Suzanne asked the question if anybody's experienced that we often suggest that if you don't have an office space to hold the mediation, you can rent a space or book a conference room at your local library or community center. Someone mentioned they had to show liability insurance in order to get a hold harmless policy to conduct the mediation at their local library. Has anybody experienced that?
No.
I have not.
So I once looked into, you know how they have this rent-a-room thing? And the problem is that when you book it, you're responsible for the cost. And mediations could be 2 hours before they can get canceled. It can be a couple of days and you're on the hook for payment. So
Yeah.
you can usually ask the court, and at the courthouse, there's usually a room or two that could be made. We're talking about court mediations, that they can make available and there's no charge for that. You really don't want to get stuck on something that you keep shelling money out for and you don't get paid for.
You can also use one of the attorney's offices if you have to in a pinch. I also think this is just for the attorneys out there. You can contact the local bar association and probably get access to a room at the county bar association to conduct it as well. We don't have any other questions from the group. I want to just give the code one more time just to make sure everybody got it. The code is the !5, F-I-V-E, !5, F-I-V-E. Since we started a little late, we're going to go a few extra minutes. I was going to ask you guys a question. Do you all limit the types of mediations that you will agree to do?
What do you mean by
I
types
do,
of
in the sense
mediation?
that-
Like construction, municipal, condo association, HOA kind. Do you employment? Do you limit, or will you take any type of civil mediations?
I advertise on LinkedIn that I do business, insurance, securities, and real estate. And generally, those are the kinds of cases that I get. Contract breaches, lots of contract breaches of all stripes. But on the other hand, I do some employment for free for the Southern District of New York, which is, you can't charge. And then the federal courts, they have a very reduced rate mediation schedule. I think it's $300 per hour. But there they don't have any limit on prep time, and they don't have any limit on mediation time. So it makes up for the low rate that they impose. So that's where I stand.
Yeah, now I won't do employment unless it's in the case of the family. And I know you're going to be talking about different family law situations or family situations. I've done one where it's a relative who's come in to be a caretaker, and they're supposed to be getting paid, and then things didn't work out. So I do get involved. But that's the only type of employment. that I get involved in. So, I do limit it to that.
You also have to understand that different panels have their own limitations. There are certain panels in, I know New York specifically, if you want to do personal injury, you have to be approved as a personal injury mediator. You have to have a certain amount of experience. I've also found that certain courts learn which type of mediations you're best at. For some reason, Queens and the Bronx keep sending me easement cases, because it seems like other mediators don't understand easements and those type of conflicts. So I've been getting a lot of those. And I don't think that's just coincidental. I think it's based upon my background and my experience. And the parties basically choose their mediators. So they want a mediator with a particular background. And they're not just going to randomly take me for an employment case when I'm mainly real estate and family.
Yeah, I wonder if they're able to find out what your past record has been in terms of the kinds of cases, not whether you resolve them or not, but the kinds of cases in terms of choosing you when they go to choose you.
Yes, it's called Google.
Oh, no, but for the New Jersey panel, you actually self-list which kind of cases
Right.
willing to take. So, and I find that depending on which court it is, if they know me or whatever, because I've had judges call me on specific issues, that construction, lien cases, I have a particular expertise in that. So I tend to get a lot more of those cases. And I actually appreciate it. It means they're actually thinking about who they're appointing as a mediator instead of just, going down the list.
Yeah. Well, thank you all very much for preparing for the mediation today, for presenting. It was very interesting. I always enjoy hearing everybody's perspectives on what they do and how they do things. I want to thank everybody for joining us today. I will keep you posted on the plans for May. We are working on either trying to move it from the 20th to a different date, or I will try to postpone my jury duty. Everybody have a great day. Thanks, Margie, Linda, and Glenn. Again, we really appreciate it.
Thanks
Thank
for
you.
having us.
Thank you. Bye-bye.
Take care.